Hi there, everybody. This is Paul Callahan. I'm the head of the Employment, Pensions and Mobility Group at Taylor Wessing in London, and I also run our EMEA General Counsel programme. So today's webinar is touching on protection of business interests in Europe. In particular, it's going to be divided into two parts. Firstly, dealing with confidential information, and then dealing with non-compete, non-solicitation provisions and other post-termination restrictions. And what we're going to be doing is we're going to be dealing with the UK, with France, Germany, and the Netherlands. And what you'll find is that in relation to post-termination restrictions, there are very different rules for each country, in the same way as you get great variety of rules within each state in the US. But in Europe, in some countries, you'll find that you actually need to pay employees for a period of post-termination restriction, whereas in others, like the UK, you don't need to do that. So turning firstly to the UK and to business information, the one thing that is always protected, whether or not you have a written agreement, is trade secrets. The threshold for whether something is a trade secret, though, is extremely high. The classic example that people give is the recipe for Coca-Cola. So it really is something that is absolutely key and crucial to the business. And although, needless to say, trade secrets and, in fact, all confidential information has to be kept secret for employees during their relationship, with that very narrow category of trade secrets, that also has to be kept confidential after the employment is terminated, whether or not there is actually any sort of written agreement at all. In the UK, as in the whole of Europe, in fact, everybody is entitled to a contract of employment. But even if you didn't have a written contract, or if you did have a written contract but it didn't contain any protection for trade secrets, they are protected as a matter of common law, and you could potentially get an injunction against an employee if they try to disclose it. With confidential information, which is basically anything that is confidential but not quite a trade secret, so a lower level of confidentiality, you can protect confidential information, but first of all, it has to be genuinely confidential. In other words, it can't be something in the public domain. In the past, and that's something that's evolving, as in the internet era, more information is actually in the public domain than may have been previously. So, for example, you may on your website give examples of your customers, if that is the case, then you can't turn around later and say that those customers constitute confidential information. Likewise, if people are connected publicly to people who are identified as clients, for example, through something like LinkedIn, then anything that may well have been a protectable confidential interest no longer is once it is in the public domain. So it is very important that anything that you as a business thinks is confidential, you don't find that it's actually lost that status because of the fact that you have put it in the public domain. Also, for something to be genuinely confidential information, it needs to go beyond just the general skill and know-how of the employee. So identity of customers can constitute confidential information, as can things like pricing, or certainly business strategies and business plans. Those would be classic examples. And again, although they are protected during the employment relationship, they wouldn't be protected post-termination, unlike trade secrets, unless there was an express agreement providing for that. Now, confidential information provisions don't have to be time limited. When we talk about post-termination restrictions like non-compete provisions later, they do have to be time limited to be enforceable. And confidential information provisions don't. They're essentially, if drafted properly, they're enforceable for as long as the information itself remains confidential. But what's absolutely key is that the categories of confidential information are clearly spelled out. What you can't do is just say that you will not disclose confidential information. You do need to say what that is in terms of category. So whether that's pricing information, customer details, business plans, they do need to be spelled out. And if they are, and you have an express provision, then courts are very comfortable when it comes to protecting protecting that information, and potentially by way of injunction if it looks as if the confidential information is about to be disclosed, or if it has been disclosed, then by way of damages if you can show direct loss. So the key really is in the contract for the confidentiality and proprietary information agreements, and making sure they're tailored and relevant and properly executed by everybody who might have that confidential information. So that's essentially the position in the UK, and my colleague Jonas Warnken is going to run you through the position in Germany.
Thank you very much, Paul, and welcome to everyone. With respect to confidential information, the situation in Germany is quite similar to that in the UK, meaning that during ongoing employment, the confidential information of employers is very well protected. And in fact, disclosing trade or business secrets during ongoing employment is even considered to be a criminal offense, which is a pretty good reason for employees not to disclose such information. And basically, even though employees in Germany are as well entitled to an employment contract, even though if you would not have one, or there would no covenants on confidentiality be included, the confidential information would very well still be protected. However, it is very common for purpose of definition of what a trade and business secret is, as well as for clarification purposes, to include such covenants in the employment contracts. However, the situation changes post-employment, after termination of the employment contract, as there is no statutory obligation to keep business and trade secrets confidential after the end of the employment relationship. So in this situation, after end of employment, it is crucial to have such provision in the employment contract and to make sure that this information is still protected. And German courts are rather generous when it comes to enforceability of confidentiality provisions, unless they are so strict that the employee really does not have any chance anymore to work in his or her area of business. There is no case law on what they define. As an example for this, it would basically probably be if you prohibit the employee to make use of his knowledge how to use Microsoft Word or anything. So that would really keep the employee from being able to work after the end of the current employment agreement. And just as in the UK, enforceability of post-contractual non-disclosure covenants ends when the former secret becomes publicly known, and at least some courts say latest after 5 years. So that's basically the situation concerning confidentiality in Germany, and I will pass on to Rosalie regarding the Netherlands.
Thank you, Jonas. In the Netherlands, most employment contracts contain confidentiality covenants. Confidential information is any information that has not come into the public domain. A confidentiality clause obliges the employee to observe the confidentiality regarding trade secrets and other confidential and commercially sensitive information which disclosure may be harmful to the employer. It is usually agreed that the confidentiality clause will remain in force both during and after the employment. There is no time limitation to the confidentiality clause. In the Dutch Penal Code, we even have a provision that provides that in case confidential information that has been imposed upon an employee, the disclosure of such confidential information during or even after termination of the employment contract could in some situation be considered a criminal offence, which could lead to imprisonment and a penalty of 6 months imprisonment. This, however, rarely happens. And even if a confidentiality clause has not been agreed upon, the Dutch Civil Code provides that disclosure of information, which the employee is supposed to keep secret, is considered a valid ground for immediate dismissal. In order to avoid confusion or misunderstanding resulting from differences in interpretation of the meaning of the law, we always advise to include a confidentiality clause in the contract of employment. Moreover, in practice, it's very difficult for an employer to prove that a former employee has violated the confidentiality clause. It's also likely that there will be a discussion as to whether or not the information should be considered confidential or commercially sensitive, and therefore it's advisable to also include non-competition clauses and other post-termination restrictions in the contract of employment. And I think we can now go to France.
Thanks, Rosalie. So in France, it's fair to say that some of the principles we've been discussing in relation to confidential information in the other jurisdictions are also exhibited. I think the starting point, and quite obviously, it's very common to include confidentiality clauses which seek to restrict the use or disclosure of confidential information and company property as well during employment, and importantly after termination. So in France, for confidential information clauses to be properly put together, that one of the key points is the first one, that it's essential for the protection of the company's particular legitimate business interests. And one of the overriding themes that we'll see throughout this webinar and that we've been discussing already is the scope and enforceability of these types of clauses. So it really will be important to define what the legitimate business interests in terms of confidentiality are in respect of a particular company. Second element is that the clauses will need to relate to confidential information, as I say, of the company. It could be anything technical, commercial, know-how, trade secret level, but not it should not relate to widely known information which is in the public domain. One point with France as well is that confidentiality clauses must be limited in time due to the French law principle about perpetual obligations being prohibited. So as we've seen, confidentiality obligations can be effective both during and after employment, and obviously it's particularly important that they are effective after termination of the employment. Another key thing to note in relation to France is that confidentiality clauses can provide for a penalty provision, which can be payable in case of breach by an ex-employee. Not as straightforward that a penalty will always be payable, and it will always done on a case-by-case basis and the relevant facts of the case. But obviously, a breach of such a clause can bring about a cause of action to sue for damages as well. So those are the key principles in relation to confidential information in France. Again, overlap with many of the principles in and across Europe. And I'm now going to pass back to Paul in the UK to talk about post-termination restrictions and all the various forms of covenant that we see in the UK.
So, as in the US, where post-termination restrictions are enforceable in most states, but notably not in California, they can be enforced in the UK, and the principles, as I understand it, are broadly the same as in the state of Arizona. So if you happen to know, Arizona's rules are pretty similar to the UK. But the starting point is that post-termination restrictions are void as a restraint of trade unless you can show that there's a legitimate business interest to be protected and that the provision in the agreement, the confidentiality and proprietary information agreement or the contract of employment, goes no further than is reasonably necessary to protect that interest. And as in most states in the US, that means that you've got to be carefully defining what is restricted and the length of the restriction, the area that it covers, and essentially demonstrate that you need the level of restriction that you're trying to enforce. Essentially, non-competition provisions which stop somebody from joining a company altogether are the most difficult to enforce, whereas those that are non-solicitation, that are basically saying that that you can't solicit clients or key employees, are the most likely to be enforced. And then somewhere in between, depending on the seniority of the person, are non-dealing provisions, where, for example, a customer comes directly to the individual rather than is actively solicited. Now, in terms of time, the key in the UK is that in a contract, in an employment relationship, a restriction cannot be for more than 12 months. But in practice, for a 12-month restriction to be enforceable, it would need to be someone very senior with key confidential information in their head. Essentially, you'd have to justify why 12 months was absolutely necessary in that case. Otherwise, it would be struck down completely. We don't have the sort of blue pencil test that you have in some states, whereby a longer period would be struck out and a shorter period would be inserted. If the period is too long in the eyes of the court for that particular individual, it'll be struck out completely. We do have a variation of a blue pencil test where if something is struck out and then the clause would be enforceable and make sense as written with that strikeout, then it can be enforced. But the courts here won't ever write anything in. So what that means in practice is that something preventing someone joining a competitor will usually be enforced only with somebody with key confidential information in their head, either a CEO or somebody who knows the key strategy or is key in relation to research and development. Sales employees can rarely be prevented from joining a competitor altogether, because the argument with them is that the key is actually their client relationships. So the non-dealing and the non-solicitation of customers that they've dealt with would be enforced in that sort of situation generally, but not a blanket non-compete. You do need to make sure that these restrictions are tailored. If you just have a precedent that you print off and get everybody to sign, then it's less likely to be enforceable. If you can show that there's been some thought in it, then it's more likely to be enforced. There's no advantage at all to paying employees for the period of the post-termination restriction. That it will either be enforceable or not enforceable on its particular fact. The other device we have in the UK employment relationship is that of putting employees on garden leave. And that is actually where an employee has given notice of termination. And because we don't have at-will employment, employees will have a notice period that they normally have to work. And if that's a senior employee, it may be 3 months, 6 months, sometimes even 12 months. The disadvantage for the employer is that they have to pay the employee for that period. But they can, if they've got an express contractual provision, put them on garden leave, which basically means they don't come into work, but they're still bound by their employment duties, and so they can't do anything that harms the interest of the company, and they certainly can't go off and join their competitor. That's often a good alternative to post-termination restrictions, albeit you have to pay them. And if you've got both in your contract, which you ought to have for senior employees, then the important thing is to have a set-off should an employee be on garden leave. And what I mean by that is that you've got to be absolutely sure that the individual won't be out of the marketplace or restricted for more than 12 months altogether. So if you do have a 12-month post-termination restriction, then you need to set that off against any period of garden leave. Because as soon as you go over that 12 months of being out of the market, then it will definitely be unenforceable. Often you need less, because 12 months really is for the most senior employees. And if you do have a provision that is enforceable, then the usual remedy with post-termination restrictions is to try and get an injunction to stop somebody going to a competitor or from soliciting your employees. So in the UK, these sort of provisions are often enforceable. There's certainly lots of letters before action threatening enforcement, and it's not uncommon to enforce these. But I'll let Jonas tell you how it's different in Germany.
Thanks, Paul. In Germany, again, during ongoing employment, interests of the employer are very well protected, meaning that during ongoing employment, employees are by law prohibited to compete with their employer. And again, for clarification provisions, we recommend to include provisions on that in the employment contract, which is also helpful to emphasize that the employer has a high interest that the employees do not compete with their employer, and often we can include some definitions with respect to the geographic scope and also further scope of the non-compete. And those restrictions always include a prohibition to entice away customers, clients, and or other employees of the company. However, the situation significantly changes after the end of employment, because the German Constitutional Court sees fundamental right of employees to be free to engage in any business activities after the end of employment, meaning that they have to be free with respect to the decision who they work for. And if a company wants to limit this right, they have to pay some sort of compensation. And for employees, this is very clearly defined in a certain act dealing with this, and this says that for the period of the non-compete, employers have to, post-contractual non-compete, that is, employers have to pay compensation at least in the amount of 50% of the last remuneration, which includes all remuneration parts, so not only base salary, but also variable pay, commission, even private use of company car, not meaning that you have to provide a company car, but you have to financially pay something for this benefit as well. And the maximum duration of such post-contractual non-competition in Germany is 2 years, so there's no chance to agree on any longer period, and this is also not connected with seniority of the employee. And in fact, if an employee is dismissed for operational reasons, restructuring or any other reasons, the employee has the right to waive the non-compete, meaning that he or she is immediately free to compete and obviously not receive any compensation, but be free to compete with the employer, unless when issuing notice of termination, the employer offers to pay 100% of the remuneration during the period of the non-compete. So this is highly expensive. The good news, though, is that you, as employer, do not in any case need to pay the full compensation, because the employee must allow earnings from other sources to be set off against this compensation if the compensation and the new earnings exceed 100% of the last remuneration. To make up an example, if your employee receives 100,000 euros per year, the compensation for the non-compete is 50,000 per year. And if this employee receives at least 60,000 in the new employment contract, anything above that would be deducted from the compensation to be paid. This threshold is higher if the employee had to move because of the non-compete, meaning that this employee is a specialist and he cannot work in his hometown because of the non-compete and had to move to another city, then it's 125% of the last earnings or the compensation together with new earnings. The employer, by law, has the possibility to waive the non-compete before the end of the employment contract, with the effect that the obligation to pay compensation ends after 12 months after this waiver. So if the non-compete is waived prior to 12 months prior to the end of employment, there is no obligation to pay a compensation at all. If the non-compete is waived 6 months prior to the end of employment, the employer would have to pay 6 months of compensation. And those covenants always include a prohibition to entice away clients, customers, or employees. For managing directors, rules are not as strict. Managing directors really meaning the legal representative of the company. For those very key employees, obviously, it is not clearly defined, which is also difficult for employers, but at least prevailing opinion is that you only have to pay 50% of the base salary, so not including a variable pay and other components. And it's possible to waive the non-compete with a shorter notice and also waive the non-compete after end of employment, so that makes it easier. One further issue not mentioned on the slides is that in Germany we also have the option of a garden leave. So a notice period needs to be observed, and employers may release employees from their duties to perform work, continue to pay, and during this period employees are still bound by their obligations, including not competing with their employer. So this is something very often used. So that's it with respect to Germany, and then pass on to Rosalie.
Thank you. In the Netherlands, non-competition clauses limit the former employee's ability to compete with the business of their previous employer. Apart from non-competition clauses, we have many other restrictive covenants like non-poaching or non-solicitation clauses. Many employees seem to believe that these clauses, these non-competition or non-solicitation clauses, can be violated without any consequences. But when such a non-compete or non-solicitation clause has been agreed upon in the right way, meaning in writing and with an employee above the age of 18, it is binding. In addition, the clause must be reasonable in terms of time and the area of restriction. The term of the non-competition clause often depends on the length of employment, yet there is no legal provision that governs the actual duration of the non-competition clause. A term of 12 months is common practice in Dutch jurisdiction, but a duration up to a maximum of 2 years is also possible. In the Netherlands, it's not customary to regulate that the employer will pay the former employee a compensation for each month in which the ban on competition applies after the contract of employment has terminated. Parties can, however, agree otherwise. And per the 1st of July, Dutch employment law changed with respect to the non-compete clauses in fixed-term employment contracts. In principle, it will no longer be possible for an employment contract for a fixed period of time to contain a non-compete clause unless the employer has severe company interests that justify the inclusion of such a clause. Well, when including such a clause, the employer must substantiate these interests in writing in the employment contract, and please be aware that the employer must indicate for each individual case which severe company interests exist, taking into account the nature of the particular position and of the company. Unfortunately, the legislator did not provide much clarity on when severe company interests are considered substantial, and therefore we currently advise our clients to describe the importance of the employee's position and the scope as broadly as possible. If the employee deals with company secrets or important clients, this should also be mentioned in the clause. When at the end of the employment contract the employer relies on the non-compete, he must be able to prove that these severe company interests still exist. Failing such a written substantiation, or if severe company interests do no longer exist, or the necessity of the clause cannot be proven, the court may declare the clause void in its entirety. Please be careful in case of a renewal of an employment contract. Renewal of the contract, explicit or tacit, does not automatically renew the non-compete clause. And in the event the position of the employee within the corporation changes significantly during the employment, as a result of which the non-compete clause becomes more burdensome, the employee may petition the court to mitigate or annul the non-compete clause. This is based on case law of the Supreme Court. Consequently, the employer has to check on a regular basis if the new non-compete clause, if a new non-compete clause has to be concluded. Compared to Germany and England, in the Netherlands we do not have garden leave. Employees can be released from work, but only with their permission. An employer can also try to suspend an employee, but they can ask the court in the interim to be reinstated, so that in the end will not help the employer. It's advisable to always include a penalty clause. The aim of a penalty clause is to impose an immediately enforceable financial penalty on the employee when they are in breach of a certain contractual provisions, such as the non-competition clause. It therefore serves as a deterrent to breach. The level of the penalty specified in the clause may be reduced by the court in certain circumstances. On the other hand, the employer may waive its right to the penalty and hold the employee liable for all the loss resulting from the breach. Well, regardless of whether the employment contract includes penalty clause, an employer is entitled to ask the court for an injunction under which the employee is ordered to refrain from further breach of one or more of the post-contractual provisions. They can also claim damages, and moreover, the court is always authorized to impose a penalty on any breach. Please be aware of the fact that an employer is not entitled to invoke his rights under a non-compete clause in case of termination of a serious imputable act of the employer. For example, if the employer terminates the contract of employment because of discriminatory grounds, it could be that the court states that the non-compete is no longer valid because of the reasons for termination. And then if no post-termination provisions apply after termination of the contract of employment, many employees feel free to compete with their former employer. In principle, they can. After their employment has ended, such an employee is free to enter into the employment of a competitor, or they can set up a competitive business. That former employee may then operate in the same field as their former employer and may also contact its customers. However, that freedom is not unlimited. Case law provides that in certain circumstances, former employees who are not bound by non-competition clause may also be acting wrongfully towards their former employer if they are guilty of unlawful competition. How can an employer force a former employee who's not bound by non-compete or any post-contractual provisions to stop the competition? If the former employer has some form of evidence, the employer will usually first order the former employee in writing to cease the wrongful competition with immediate effect. In addition, the former employee can request the court, usually in summary proceedings, to order to cease and desist from all wrongful acts with immediate effect, and to prohibit the former employee from contacting and maintaining contact with customers or other contacts of the former employer. The court can also order the former employee to return all digital and other company information of the employer that's in the employee's possession, accompanied by a written statement signed by the former employee that he no longer has any digital or written copies of that information in his possession. The Dutch Supreme Court has ruled that competition by a former employee is not admissible if the former employer can prove that the employee has done systematic and substantial damage to the long-term market of the former employer that the employee has helped to establish during his employment, using the tools with which the employee was confidentially provided with by his former employer. In that case, the former employee is abusing his freedom of contract. Well, in determining whether wrongful competition is involved, it must be established whether the circumstances of the case jointly fulfill these three requirements. And the most relevant circumstances are if the employee is abusing the knowledge, contact details of clients, experience, and personal goodwill acquired at the former employer, and consequently making offers by which the former employer is sidelined, and making, for example, incorrect, negative, harmful statements about the former employer. In addition, the new employer that employs the former employee can be held accountable. In certain circumstances, the former employer can claim damages from the new employer. This might be the case if the new employer has deliberately induced the employee to breach their contractual provisions and the new employer unlawfully profits from such a breach. Employers' claims are often disallowed in court because the former employer cannot adequately prove the wrongful competition. Gathering and presenting evidence often presents, in practice, most problems in cases like these. So better be safe than sorry. So always include the non-competition clause or non-solicitation clauses. James, please inform us about the French situation.
Thanks very much, Rosalie. So some interesting principles permeating Europe in relation to post-termination restrictions, and we're going to finish up now with France, as Rosalie said. So I think the starting point is, as you'd expect, it's pretty common, particularly for senior level employees, to have post-termination restrictions in the contract. Again, some similar principles that we've seen, that they will be unenforceable unless provision is justified by nature of the duties performed by the particular employee, and that needs to be proportionate to the aim that's pursued. The French labour courts, when they're looking at the validity of covenants, will consider a number of things, and these would include the role of the employee, so what they do, how senior they are, the duties they carry out, the nature of the employer's business, and also the scope of the restriction, so the type of activity, geographical scope and duration. So again, principles that we've seen already today. There are, as we've seen in Germany as well and Netherlands, certain restrictive covenants that need to provide for financial compensation, and we'll speak briefly about these shortly. So in France, what are the general principles? So non-compete provisions to be enforceable and valid, they need to be in writing. Contractual non-competes as well must not be any more restrictive than those that derive from collective bargaining agreements, and I think you'll all be at least vaguely familiar with collective bargaining agreements throughout Europe. Again, as I said, they must be limited as to their duration and particularly their geographical scope, and they must be deemed to protect an employer's legitimate business interest, and this is something that keeps coming back to us, and it really is important to focus on what the business interest of the company is and tailor the covenant to that. It needs to be proportionate to the employee's duties and to their level of seniority. So, what might work for a junior employee won't necessarily be the case for a senior employee. They also need to provide for reasonable financial compensation, and we have some percentages that I'll share with you shortly. The court in France will look closely at whether, given the employee's duties and position in the company is likely, and this is the key bit, to incur a significant economic and commercial risk if the employee actually competed with the company that it's leaving. During the duration of the non-compete covenant, employees, as I say, need to be paid. Now, it can actually be anything from 30% up to 100%. Again, depending on the employee and the covenant, but the average seems to be about 30 to 50% of gross monthly remuneration, and this is the figure that's likely to be considered reasonable for such restrictions. An interesting point, and I think you'll find, is that compensation needs to be paid regardless of the grounds for termination. So even in the case where someone has been dismissed for gross misconduct, compensation still needs to be paid for the non-competition restriction. Financial compensation can also be paid in one instalment on termination, or in fact a series of instalments during the performance of the non-compete covenant, so it can be staggered across the duration of the covenant. What you can't do, however, is delay the payment until the end of the non-compete covenant. Non-compete covenants can also be void if non-financial compensation is awarded or the amount is too small. There are also, in France, contract prohibition clauses, and in terms of validity, they have the same principles as those that I've just outlined. And these type of clauses should be considered as less restrictive than non-competition covenants. But courts consider this type of covenant, if it does prohibit an employee from contacting or being contacted by clients of a former employer, potentially to be a restriction of the freedom to work. Contract prohibition clauses should provide for financial compensation if the employee is prohibited after employment termination from contacting most clients of the former employer or most clients that this departing employee had contact with during the performance of the employment. Again, the type of financial compensation that you would be looking at on average would be about 30 to 50% of the gross monthly remuneration. In France, there's also a non-solicitation covenant, and this defines employees who cannot be approached or hired by reference to their seniority, their grade, and the role that they perform and how important that role is to the business. Besides the colleagues, for departing employees who had a reasonable level of contact with or knowledge of or responsibility for and within a defined period before the employee left. This is probably, it's fair to say, the weakest form of covenant, as it's difficult to show that the breach of covenant where an employee was hired by a former colleague. Again, and this is probably the key underlying principle in France, that it's valid as long as it doesn't restrain the employee's freedom to go and work and be hired by a competitor. For these types of clauses, the non-solicitation clauses, no financial compensation is usually required. There's been a number of interesting principles that we've looked at throughout today, both on confidentiality and post-termination restrictions. I'm now going to hand back over to Paul Callahan to round up.
Okay, so I hope you found that helpful. We've run out of time in terms of taking any questions now, but you do have all the speakers' contact details in the slides, which will be emailed to everybody who has signed up for this webinar. Needless to say, if you have any questions at all about this or any other European legal needs, don't hesitate to contact me. Thank you very much for participating. Our next EMEA General Counsel webinar is in December, and that will be covering pension plan issues across the EMEA region. Thank you very much.